When a couple decides to separate, there are many things to figure out: separation of property, child custody, and child support. Well, we've called in divorce lawyer Tanya Davies to help answer some of your questions. Tanya, good morning. Thanks for joining us.
Good morning. Thank you.
All right, let's get to some of our questions from our viewers this morning, and we're going to start with the first one. And this one is from Samantha. She writes, I've been married for 6 years. We don't have any children or house or assets. We separated, but I don't know where he is living now and can't find him on social media. Can I still get a divorce? What do you think, Tanya?
Yes, you can, but in terms of procedure, it's going to be a little bit more complicated. So normally what you need to do is to actually serve the person physically with the documents for divorce in court, with the process server. And if she doesn't know where the person lives, she can obviously maybe phone around, contact his friends or relatives, try to contact him by email if she has it. And if she still has no success, she will need to bring a motion in court for substituted service. So that would be serving the person, maybe posting an ad in the paper, posting it on social media, and making an assumption that the person received the message.
I mean, it sounds in a way like maybe if he is trying to avoid her and not have that communication with her, does she have any option to still get a divorce if she absolutely cannot find him through any of the means you suggested?
Again, then she needs to bring a motion for substituted service. And if the judge allows to post an ad in the paper that she's proceeding with her divorce, or post an ad on social media, if the judge deems it to be appropriate, then it would be considered proper service.
All right, let's get to our next question. This one comes in from Myron. And Myron are refusing to come to my house now. My ex is not encouraging them or maybe even alienating them from me. What can I do? This is a real tough one, I'd imagine here.
So in that situation, if there is a court order in place for access, but the ex is saying my child doesn't want to see you, or if there is no court order or parenting agreement, what you need to do is bring a motion in court and ask for the appointment of the office of the children's lawyer. So if the child is young, they would look into the issues of, is it in the best interest of the child to see the parent? Is the other parent in contempt of the court order? Are they denying access for inappropriate reasons? And they would provide an assessment and recommendations to the court. And if the child is a teenager, you can actually appoint a lawyer for the child from the OCL to ascertain their views and preferences.
All right. Next up, this one from a viewer named Dale, who writes to us, I lost my job during the pandemic and don't know that I will be rehired. I don't have money to pay my child support. Is there a way to stop my FRO payments?
There is. You cannot contact FRO directly because they're simply an enforcement agency. They don't make any decisions. But what you can do is bring a motion to change in court based on a material change in circumstances, the change being loss of employment, and the court would put payments on hold at least temporarily, and then that order would be sent to FRO.
All right, Tanya, thank you as always answering our questions for our viewers on divorce and separation. Tanya Davies from Davies Law Firm. Thank you.
Thanks very much.